Good morning. My name is Rob Sterne. I'm from Washington. I'm here to help you. I want to talk today about our new contested world, our new patent world of contested proceedings, which is probably the most significant change that we have seen in the patent enforcement landscape in the United States of America since the very beginning of patent litigation, and perhaps is even more significant in terms of its practical effect than the creation of the United States Court of Appeals for the Federal Circuit in 1982. Now, what was the promise of this new regime of testing patentability in the Patent Office while you're simultaneously testing the validity of the patent in the district courts or in the International Trade Commission? And the promise of the statute was that there would now be a serial enforcement process where the patent owner would go to court or to the ITC, and then the issue of validity would be transformed into a patentability determination, a second patentability determination, if you will, that would be conducted at the United States Patent and Trademark Office New Patent Trial and Appeal Board, or at the Central Reexamination Unit, depending on which proceeding was instituted. And the idea was, of course, that if you could test that in the USPTO and then go back to the district court or to the International Trade Commission, you would get some significant benefits. And so the new strategy under the law was a serial enforcement approach as compared to the current approach that existed before the new law went into effect on September 16, 2012, in connection with the contested proceedings of a parallel system where you would bring a suit in the district court or in the ITC, and at the same time, the validity of the patent claims in question would be tested in the Patent Office in an ex parte or an inter-party re-examination. But I would submit to you, based on a lot of discussions with judges, for example, last week in the patent pilot program, these are the judges that are going to be handling many of the patent cases going forward under this new 10-year patent pilot program, that there is great uncertainty in the U.S. judiciary, and there's also great uncertainty at the U.S. ITC as to whether this serial regime is one that they're going to actually embrace. And it's quite possible that we will still see parallel proceedings going on where one or more of these contested proceedings will be ongoing at the same time that the district court or the ITC or both are dealing with the same patent in an enforcement situation. So the U.S. is not going to the system used currently in Germany, for example, where in Germany you bring a lawsuit, and you've seen this perhaps in the cell phone wars, you bring a lawsuit in one of the regional courts, typically in Mannheim or Dusseldorf, and then the accused infringer takes the patent case into the federal patent court in Munich for a nullity proceeding to determine whether the patent should have been granted in the first place, but that only occurs if the patent is found to be infringed. And the way that the German system works could be quite similar to what we could be seeing in the U.S. in the future. So the promise of this new contested proceeding was that it was going to be faster, cheaper, and better than what we have before. So let's ask the question, is that true? Is it going to be faster? Well, under the rules that were promulgated by the PTO on August 14th of this year, the system works where you have a 6-month period from when the proceeding is filed to when the suit is instituted at the new Patent Trial and Appeal Board. And the Patent Trial and Appeal Board has to conduct the trial within 12 months by statute, except in special circumstances, which can extend it out to 18 months. So doing the math, 6 months plus 12 months, or 6 months plus 18 months, you see that the time frame at the USPTO for one of these new contested proceedings will be between 18 and 24 months. In addition, there is an appeal route to the Federal Circuit, that will hear all appeals from these contested proceedings at the trial board to the Federal Circuit, and that, under current Federal Circuit backlog and practice, is going to take 9 to 18 months. And that's for the briefing, the oral argument, and the final decision. So you can see that the new proceedings could take between 27 months and 36 months to complete. And this is a long period of time, particularly when you're dealing with a very quickly changing marketplace where huge money is involved. So question whether this would be faster. Also, when this is compared to the International Trade Commission, which typically completes its proceedings within 18 months, or when compared to fast-moving courts like the United States District Court for the Eastern District of Virginia, which we're in right now, which can do a case in 7 to 9 months, you can see that this necessarily is not going to be faster in these rapidly moving tribunals. And of course, these rapidly moving tribunals are creating discovery issues and making rulings that will have to be dealt with in some way by the Patent Office in these contested proceedings if they're going on in parallel. So I question, as many do, whether this will indeed be faster. Let's talk about cheaper. I would estimate, based on looking at the rules and the fact that I am now in about 9 of these inter-party reviews, of which this is about 27% of them that have been filed, and in doing budgets for these and in working with others, that the cost for bringing one of these contested proceedings or defending one at the Patent Trial and Appeal Board will be between $300,000 and $1 million, which sounds like a lot of money. But when you compare that to the validity component of a district court case or an ITC case, you can see that these numbers are not out of line. That portion of those cases oftentimes can be more expensive than the $300,000 to $1 million when the validity component is parsed out of those enforcement actions. But $300,000 to $1 million for a little company or a startup could be crippling, if not fatal. And one of the big fears, frankly, that people have expressed to me in the course of writing this book is that the little companies and startups could be essentially held up or taken hostage by large companies with money who bring one of these contested proceedings against their patent portfolio and use it for leverage to obtain desired commercial benefit. So the cheaper issue is one that we need to keep our eyes on. In addition, you have to factor in the cost of the appeal to the Federal Circuit. You cannot ignore that. And that could easily be $200,000 to $500,000 at the Federal Circuit. The reason being that the briefs will be extremely important because of the deference, the Zerko deference, that will be accorded to the PTO's rulings. And therefore, under that scenario, you're going to need to be very concerned about putting together very strong and persuasive briefs. In addition, I would argue that you would probably want to have an oral argument, and you would not want to have an oral argument that was not very well vetted and prepared. And therefore, I think the $200,000 to $500,000 estimate is not low or high. So whether or not it is cheaper is still subject to question. So let's talk about better. Now, the argument for this new contested proceeding regime was that the Patent Office, as the administrative agency that has deep knowledge of patent law and the technology, would be in the best position compared to the courts and the ITC to deliver the kind of administrative decision on this critical patentability issue. But who knows? And in addition, there are fundamental differences between the decision-making process at the PTO and what goes on in court, specifically different claim construction rules. In the courts, you have the Markman rule, ruling on the claims, which is often narrower than the broadest reasonable interpretation that is made of the claims in the contested proceedings. Moreover, in the district court, patentability is considered to be presumed by clear and convincing evidence, so there's a high burden of proof that the accused infringer has to bring in terms of these challenges in the courts. Whereas in the Patent Office, it's preponderance of the evidence, and essentially, once the proceeding is instituted, you can assume that the Patent Office has already made the initial prima facie determination that the claims are not patentable. And now the patent owner is in the difficult position of turning that around. So there are fundamental differences between these two proceedings. And moreover, the way the rules have been written is that the actual proceeding is going to be very truncated. There will be limited discovery. There will be limited oral hearing. So who knows if the administrative result will be more accurate and more fair and more just than you would get under the comparable district court or ITC approach. So let's take a look at what's going on, because this is a very complicated area. First of all, we still have the Central Reexamination Unit at the USPTO. Many of you know this is the unit that handles all the reexams since 2005. It will handle the legacy Interparty reexams that were filed before or on September 15th, 2012. And it will also handle the new ex-parte reexams that get filed, as well as the legacy ex-parte reexams, and also the new supplemental examinations, which we'll talk about in a minute. The CRU, as it's often referred to, is staffed only by patent examiners who had to have reached the rank of primary before they were detailed into this unit. It's not a permanent position at the moment. There has been work on that for several years, but it's not. So the examiners that are in this are brought in for the normal examining corps. It's headed up by Remy Ussel, who's the third director that the CRU has had over its history since 2005. A lot of the senior people in the CRU have left, either going to the board or going back to the examiner ranks, or frankly going to law school. So some of the most senior people that were in the CRU 2 or 3 years ago when I spoke to you are no longer there. So there is a lot of question in the CRU, I am told, in off-the-record conversations at the office over what will be the future of the CRU in a couple of years, and how is the CRU going to effectively operate over the next couple of years. And we'll talk about why that is important when we get to one of my predictions, which is called the spike. So we also have the Office of Patent Legal Administration. This is headed by Brian Hanlon, who's an attorney. He has 19 other attorneys in his group, in his OPLA. The OPLA handles all of the petitions that arise in the reexams, and there are often many. And there are a myriad of different types of petitions that have been filed over the years. They have to rule on these petitions often. Some of the petitions, such as the extensions of time, are ruled on by the CRU. So there is no direct coupling between the CRU's proceeding and the OPLA's proceeding, and oftentimes criticism is raised because the OPLA will take quite a bit of time to rule on a critical petition, and by the time they do, the CRU has passed that by, and now there has to be some kind of retrofit of this proceeding to deal with that decision making. But the OPLA has been extremely busy in the last couple of months dealing with the fee setting and other AIA provisions that don't deal with the contested proceedings. And so you can expect the backlog at the OPLA to continue to build because of the many reexams that are still ongoing. So ex parte reexam, we've had this since 1980. It was originally put in as a quality measure so that the patent owner could have the quality of the patent tested before she went out to license or litigate the patent. It's based only on prior art that it consists of patents and printed publications and obviousness double patenting challenges. Obviously, if you make admissions in the prosecution of your patent or in the reexam or frankly in the district court, these admissions can be used against you as well in the ex parte reexam. Once the reexam is filed by either the patent owner or the third-party requester, the patent owner is given a patent owner response that they can file, which typically is not done. If, however, the patent owner files that response, once the ex parte reexam is declared, and 90% of them are declared historically, then the third-party requester gets another response to that patent owner response. But if there's no patent owner response filed, once the third-party requester files the ex-parte re-exam, they're out of the process. The patent owner is permitted to have substantive communications with the 3 examiners that are assigned to every ex-parte re-exam at the CRU. They can have substantive communications, but the third-party requester cannot. The patent owner can go in for an interview, and I've had probably 75 of these interviews in some very high-profile patents, including the I-for-I patent that went to the Supreme Court, the Unilock patent that went to the Federal Circuit on the 25% rule, and a lot of the Apple patents that are involved in a lot of the litigation that you've been reading about in the papers. The interview is a critical process and must be undertaken very seriously by the patent owner. The patent owner has the opportunity to tell the story of the invention and to provide evidence of non-obviousness and lack of anticipation using technical experts with 132 declarations or swearing behind prior art references showing conception and diligence using a 131 declaration. So ex-parte re-exam is a specialty in itself. Many people consider it to be much more favorable to patent owners than inter-party re-exam, and I would agree with that. So let's talk about inter-party re-exam, which came into existence in 1999 and was very slow to be embraced. If you look at the PTO website, you'll see that very few inter-party re-exams were filed initially, starting in 1999. But there's been a huge upsurge in inter-party re-exams, and before the law went out of availability for inter-party re-exams on September 15th, we saw over 600 of them get filed in the last year. 600. So we've gone from 0 to 600. The important thing about the inter-party re-exam is that the requester is the only party allowed to file it. The patent owner or people in privity or real parties in interest are not allowed to file an inter-party re-exam. There is no substantive communications between either party and the central re-examination team of 3 examiners. Again, the inter-party re-exam is handled at the CRU. No substantive communications, no interviews, no ability for the examiners or the 2 parties to have any kind of dialogue. And I've criticized this repeatedly, as has others in the Patent Office, even though they could, under the rules, have refused to grant any type of interview. And I believe, in my discussions with Joe Mittal and others about this, that this is one of the reasons why we have a hearing and a board in the new inter-party review. Inter-party re-exam is all on the papers. There are no limits on the number of challenges you can make in the inter-party re-exam request. It can be hundreds and hundreds and hundreds of pages long, and often is. You can challenge a claim with multiple proposed rejections involving anticipation and obviousness rejections. You can have 5, 10, 15, 20 proposed rejections against each claim. This is in stark contrast to what you can do in the district court, where by necessity you have to narrow down and winnow down your defenses because of the very limited amount of time that you have to try your case. So in the district court, you might have 5 or 10 or 15 defenses, but you cannot really raise them as a practical matter. In the inter-party re-exam process, you can raise them all, and it only takes one of them to win to take the claim down. The statistics show that patent owners fare much worse in an inter-party re-exam context than they do in the ex-party re-exam context. And I think it's due to 2 reasons. One, there's no interview or substantive communications. And 2, there are really no effective limits on the number of challenges that can be made. And therefore, without the ability to have that kind of dialogue with the examiners, you cannot convince the examiners, as a practical matter, that many of the proposed rejections are in fact cumulative. Supplemental examination came into effect on September 16th of this year. Essentially, it was a compromise, I am told, over the elimination of the inequitable conduct defense in the patent law in the United States. Supplemental examination allows a patent, an issued patent, to be examined in terms of information of any kind that was not brought to the attention of the office during the original prosecution that could implicate some type of inequitable conduct charge in an enforcement proceeding. It has to be brought before this inequitable conduct charge is raised. So it's presumed that the patent owner would go to the patent office and have one of these proceedings before they went to enforce their patent, so as to insulate or inoculate their patent from an inequitable conduct charge. Once the patent office determines that there is a substantial new question and that there was no material fraud committed in the case, because if there is, they are charged to refer the case to the Department of Justice. It'll be interesting to see when that first happens. But once the SNQ is found, as it's called, the substantial new question, in other words, there's enough here for the Central Reexamination Unit to conduct an ex parte reexam. A certificate issues, and then the proceeding, which is, of course, has been ongoing from the beginning at the Central Reexamination Unit, morphs into an ex parte reexam. Except this is an ex parte reexam that is brought by the patent owner on any type of information. So in a way, it's an ex parte reexam on steroids for the patent owner, because the patent owner can bring up anything that they want to have the office bless or rule against in terms of patentability challenge. Now, as of about a week and a half ago, there had been no supplemental examinations filed. Does anybody know if any supplemental examinations have been filed to date? I don't know if this proceeding is going to be embraced, and the reason for that is that many people are concerned about inequitable conduct being created by the actual supplemental examination process. In other words, under Theracense, there was this thinking that the inequitable conduct defense had been much weakened, which it had, perhaps, in connection with failure to disclose references. But any affirmative statements or representations that were made can still constitute, under the Theracense case law, inequitable conduct. So as you can see, if you make statements in a supplemental examination, those actual statements or the statements made in the district court or others around the world could be used against you, arguably, for a new charge of inequitable conduct. So we will see over the course of the next couple of years whether this proceeding will be embraced by patent owners. Perhaps it will be in the limited situation where a patent owner buys a portfolio and wants to scrub that portfolio before they license or enforce it. Maybe it will be used there. But there are many people, including some at the office, who are concerned that this proceeding will not be embraced and that the Central Reexamination Unit over the course of time will have very little work to do, because supplemental examination and regular ex parte examination, once the legacy inter-party reexaminations are completed, will be all that the CRU has to do. So let's talk about our new court. Is it really a court? Well, not really. It's more of a board. It's more of an administrative board, because it's not going to have live testimony, as the rules have been written, in the actual hearing. The hearing is not going to be like a district court hearing or an ITC hearing that will last for hours and hours with people on the stand and cross-examination and the ability of the judge to ask questions, or the judges, because there will be 3 judges in every one of these proceedings, 3 administrative patent judges, all of whom are legally trained and all of whom are lawyers. But those 3 judges will not be able to ask any questions of witnesses because there will be no witnesses. Discovery will be in the form of depositions, but in fact, the depositions that will be allowed to be taken, and they're limited, will in fact be the actual trial testimony, because you will reference those in your briefs and your presentation at the board, which will only be 30 minutes to an hour long total in your presentation. And so when you're dealing with these depositions, you will in fact be creating your trial testimony. And hopefully, the board members will go back and look at these deposition transcripts or look at the videos, if there are videos of them. But there won't be what you would be expecting, perhaps, a full-blown, robust, one-day hearing at the office like you would get for an opposition at the EPO in Munich or in The Hague or in Berlin, where you would oftentimes have a one-day hearing in an opposition, or maybe in certain cases, several days. And on Monday, I'm going to be meeting with the opposition branch in Munich, and I'm going to talk about this big difference. So the process is you have 3 judges, you have You have this 1-year period once the trial is instituted for all the discovery to take place. But actually, the hearing occurs about the 9th mark, and then the final written decision from the 3-judge APJ panel has to be rendered within the 1-year statutory requirement unless it's been extended to 18 months. There's been extensive hiring that has gone on. The Patent Trial and Appeal Board has over 150 new judges, or judges total, many of whom are new, and there's an extensive training program that's going on as well. And many of the people that have been recruited are very experienced. But again, we're going to have to see in practice how this process really works and whether the right results are obtained on these patentability issues. So there are several contested proceedings that you need to worry about. And if you're a patent owner, you could be facing 2 or more of these against your single patent brought by 1 or more challengers. And we'll talk about multiple proceedings. But first of all, post-grant review. You don't really need to worry about this until you have a patent that's filed under the new first-to-inventor-to-file system. In other words, the only patents that are eligible for post-grant review have to be filed under the first inventor-to-file system, which means patents filed on or after March 16th of next year. Those patents will be subject to a post-grant review once they issue for the 9-month period that exists from the time they issue to when this period times out. Any defense under Section 282 can be raised, except best mode. So, for example, you could raise offer for sale, public use. You could raise problems with the specification or with the claims, in addition to patents and printed publication prior art. You could raise 101 statutory subject matter, and I would submit that will be raised, particularly in certain technologies such as personalized medicine. So the PGR, as it's often referred to, is this 9-month window where once the patent issues, it could be attacked by a third party. Now, the third party cannot have also filed a declaratory judgment action against that patent. They can't be in 2 tribunals at the same time. And there's also some rules in PGR where if the patent owner moves very quickly after the patent issues, they can effectively preclude PGR. But as a practical matter, you are going to have this window of 9 months where your patent could be attacked on any grounds. Now, the thing that you need to know as a patent owner is, are your patents going to be monitored during prosecution by your competitors? And we don't know. The law of willfulness has gotten much less strict. So it's quite possible that patents will be monitored now by competitors so that they don't lose this PGR option. Interparty review. Interparty review replaces Interparty Reexam. It's limited to patents and printed publications prior art. It can only be brought 9 months after the patent issues. And if the patent has been in suit for more than a year, in other words, the challenger has been served with the suit for more than a year, they can't bring an IPR, which is one of the reasons why there were a lot of Interparty Reexams filed when the Interparty Reexam started to sunset in September. The Interparty review, unlike the Interparty Reexam, will be handled solely by the Patent Trial and Appeal Board, just like the PGR. So you'll be under this very fast track, no extensions of time regime in front of the board. There have been about 30-some filed so far. Not as many, perhaps, as the Patent Office was expecting, I think. And so this is going to, the first ones that have been filed are in many different technologies. And there's going to be a lot of the issues that are lurking in the statute that will be surfaced, I submit, by these initial IPRs. I feel fortunate to be involved in IPRs already, both from the challenger side and from the patent owner side. I can tell you that it's akin to being in the US ITC or the Rocket Docket in terms of the burdens that it places on the clients and on the defense teams or the prosecution teams. So what you need to know is if one of these reviews is filed against your patent, you need to immediately move on figuring out how you're going to deal with this, because this is a very, very significant challenge just from a logistical perspective. How the Patent Trial and Appeal Board will deal with issues of patentability compared to the Central Reexamination Unit in Interparty Reexams will need to be seen. In other words, will patent owners fare better here in IPR than they would in the prior Interparty Reexams? Section 18 proceedings were brought into the law by Wall Street. This is Wall Street lobbying at its best. It allows for a creation of what many would call a second-class citizenship for certain patents that find themselves in the technology space of financial patents that don't have a technical component to them. What patents and what patent claims are covered by this new proceeding is uncertain, and it's clear that this will be tested in some early cases as to how expansive the definition will be for the patents that will be covered by these proceedings. But if there is a financial component in the claims, you better believe that a Section 18 proceeding may be brought. The proceeding can only be brought if the challenger has been sued or challenged or threatened with suit. And we don't know what threatened with suit means, but many people think it's akin to DJ jurisdiction for filing a DJ action. Any defense, like PGR, can be raised. It's not limited like inter-party review. In other words, statutory subject matter. Offer for sale, public use, problems with the specification, problems with the claims. Patents or printed publications. The important thing to know is that you can file more than one of these as a challenger, and frankly, that's already been done. So you could file one against a certain set of claims for statutory subject matter, and you file another one against another set of claims for 112 issues. So this could put a huge burden on anyone who has a patent. Moreover, the statute has a provision that talks about a heavy favoring towards the court granting a stay of its proceeding, or the ITC granting a stay of its proceeding, once one of these is filed and the trial is instituted. We don't know when that kicks in, and it will, of course, be subject to litigation, but there is a heavy presumption that the other tribunal should stay its proceeding subject completion of this CBM, as it's called, the Covered Business Method proceeding. In addition, there's another burden that's been imposed on the Federal Circuit, and that is the interlocutory appeal of the stay decision, regardless of what it is. In other words, once the stay is decided on, whether it's granted or not, there is an interlocutory appeal of that decision from the District Court of the ITC to the Federal Circuit. And how the Federal Circuit will deal with this, because there's already been over 10 CBMs filed, will need to be seen. It's predicted by the Patent Office that there will be 50 of these the first year. This could be a major burden on the Federal Circuit if it has to decide a whole bunch of stay decisions on top of its normal appeals. This is a very controversial provision and one that we're going to need to watch very carefully. Derivation proceedings, as we talked about earlier, are complicated. They don't come into effect until March of next year. And so I'm not going to go into them today because we've discussed them earlier, other than to say they replace interferences and they deal with the situation where the allegation is that one party derived or stole the invention from another. They will be handled by the Patent Trial and Appeal Board, and there's a set of rules that exist surrounding them. The trial, as I said earlier, is going to be very fast. 6 months before it's instituted. Once it's instituted, no extensions of time. You'll be getting your hearing. There will be orders. It's going to be extremely fast. There will be one judge out of the 3 that will be primarily shepherding the case before you have your hearing. You must read the practice guide. You must read the rules. You must really start to understand the burdens that you face, for example, in trying to show non-obviousness. I am very concerned about that subject, and I'll talk more about that in a minute. The prospect of multiple proceedings is extraordinarily real. And in chapter 21 of our book, which I'll tell you about more, later. In chapter 21, I wrote 13 hypotheticals on how all these multiple proceedings could be brought and how track one patent prosecution would dovetail in. And what would happen if you had multiple proceedings, one PGR, one ex parte re-exam, one covered business method, one inter-party review, multiple inter-party reviews. Think about it. If you have a patent that's being enforced against more than two or more defendants, there's a high probability that each defendant is going to bring their own proceeding. But the statute requires that they all be done within 12 months. So how is the Patent Office going to manage multiple proceedings, particularly if they're staggered in time or they're different types of proceedings, some of which are at the CRU and others are at the board? No one knows. No one knows. And I can tell you that the Patent Office in the statute was given wide latitude on how to manage multiple proceedings. And I can also tell you that the Patent Office has told me that they think that the first proceeding often will be the determinative proceeding, but I beg to differ because I think that each of the proceedings will need to be given its own day at the Patent Office or its own day at the board. So how this will work in practice will need to be seen, but it's a very real issue. Estoppels are a very key piece of the puzzle here. Now, the estoppels are based on the premise that you can't get two bites at the apple. You can't get two bites at the validity, patentability apple. And by that I mean, if you've challenged the patent claim in the court, in the ITC, or in the office on a particular piece of prior art and a particular proposed defense, why should you be able to get to relitigate that again if you're not successful the first time in taking the claim down? In other words, shouldn't the claim get some respect after that? That's the basic thought. And that's what's behind the estoppels. But the estoppels really vary depending on the proceeding involved. And as I said earlier, the multiple proceedings even make it more complicated because you could have multiple proceedings against the same claim involving different defenses, for example, or maybe even the same defenses, or colorable variants of those. So let's go through the estoppels. Now there's two estoppels. There's the estoppel of the, actually there are three estoppels. There's the estoppel of the patent owner, excuse me, the requester, the challenger. There's estoppels against the challenger re-arguing the same challenge in multiple proceedings at the Patent Office. That's the first estoppel. The second estoppel is the estoppel from the district court proceeding to the Patent Office proceeding. In other words, if the district court has already ruled on this defense, will the Patent Office give full faith and credit, so to speak, to that ruling in its proceeding? And then the estoppel that I really want to focus on, which I think is the most important for our discussion today, is the estoppel between the Patent Office and the court, or the estoppel provision from the Patent Office to the ITC. So let's talk about the third one. Ex parte re-exam, there are no estoppels. So you can have multiple re-exams filed by one or more parties involving the same or similar art, and that's often happened. That happened in the Eye for Eye case, that happened in the Unilock case. It's happened in a lot of my cases where we win the first ex parte re-exam and we face a second one. And oftentimes we're charged with inequitable conduct as well. It's my consolation prize. But what I'm talking about here is there's no estoppel in ex parte. In inter-party re-exam, the estoppel is raised or could have raised, and that's never been litigated. And we don't know what could have raised means. Is it anything that could have existed out there in the prior art, or is it just what a reasonable searcher could have found? We don't know. Next is post-grant review and inter-party review. Now the estoppel here is raised or reasonably could have raised. Reasonably could have raised, as opposed to could have raised for inter-party re-exam. So what does reasonably could have raised mean relative to could have raised? I don't know. Perhaps it's a less onerous estoppel on the challenger. Who knows? Now for the covered business method, it's raised. It's limited to raised. And finally, I want to note that the technical amendment discussion we had earlier also applies here because there is a huge argument that's developed over the estoppel for post-grant review where some people are arguing that there was a drafting error and that the estoppel should have been the same for post-grant review as it is for covered business method. In other words, it's very narrow and it's limited to what was actually raised. Other people say this is a bunch of bunk, give me a break, this is the big train robbery, and that this is not a drafting error, and that that was the legislative compromise, which was the estoppel extends to what reasonably could have raised. We'll see how that plays out. But these estoppels and how they work together are important. One final point on this. The estoppels in inter-party re-exam do not kick in until all appeals have been exhausted, which oftentimes takes 5 to 8 years, and which is often why an inter-party re-exam was filed as a defensive move by accused infringer over the last couple of years. But the estoppels in the new law for the new proceedings attach as soon as the final written decision from the board is issued, which is much sooner because that's before you go on appeal to the Federal Circuit. So the question asked by many, including myself in the book, is what happens if the Federal Circuit reverses? How does that work? We have a provision allowing for third parties to submit prior art in ongoing prosecution, very low fee. Query as to whether this will actually be used a lot, but it's in the law. We have a huge prosecution overlap, particularly with fast-track, track 1 cases, continuations, and reissues, as they relate to these contested proceedings. And in the book, we have a whole chapter on this because, frankly, this is the patent owner's very best friend, which is keep a continuation application alive no matter what, and be very cognizant of the ability to modify your claims or get additional claims based on what's happening with the contested proceedings. Now let's talk a little bit about the interface between the Patent Office and the District Court, which we talk a lot about in the book. You've got different rules for claim construction, different rules for protective orders, different rules, different timelines, different discovery scopes, on and on and on. Question, whether you'll be able to bring in your discovery from your district court into your proceeding at the office. Probably not as a practical matter, but why shouldn't you? It'll be used against you if you're the patent owner. And I can tell you that the judges, as I said at the beginning, many of the judges in the patent pilot program do not know whether or not they're going to stay their proceedings pending completion of the PTO proceedings. So this interface between the office and the federal and the district courts is a big, big deal. There's also a big deal going on between the office and the ITC. I talked with one of the most senior judges at the ITC recently at a conference in San Francisco, and he said, we don't know if we're going to stay or not stay our proceedings in light of the new proceedings. Historically, with the re-exams, because they took so long, and even the ex-party re-exams that didn't take as long in many cases, the ITC would not stay because they have a legislative mandate to complete their proceedings in a very short amount of time, typically 18 months. So my prediction is, at least for the beginning, the ITC will not stay at Section 337 proceedings. But if it should start doing that, that's a fundamental change in the landscape. The interface between the office and the Federal Circuit is huge. Historically, there are 100 cases brought to the Federal Circuit from the PTO. There's going to be a huge increase in appeals to the Federal Circuit. And this has been discussed with the judges there. When I was at the Princeton conference in June, this was discussed extensively. Let's do the math. We've got the required mandatory stay appeals from the covered business method proceedings. That could be 50 to 100 a year. The PTO historically has 3% appeal rate from original prosecution. There are 27,000 cases backlogged at the board from original prosecution. Now, Chief Judge Smith from the board, he's recruited all these new judges for the contested proceedings as well as for the board in general. They're going to train a lot of these judges on ex parte re-exam appeals. Let's say, for example, that he is able to do what he wants, which is to reduce the backlog by 20,000 cases in 3 years total. If there's a 3% appeal rate historically from those types of cases to the Federal Circuit, that's 600 cases or 200 cases a year. So now the Federal Circuit has an additional 250 cases being appealed. On top of that, we have all the appeals from the ex parte and inter parte re-exams. There's probably 1,000 or more pending at the moment. So some of those will be appealed, particularly the inter-party re-exams. And last but not least, all the new contested proceedings that are going to be filed. So you can see that there could be 400 to 500 to 600 appeals to the Federal Circuit a year from the office. And I'm sure the Federal Circuit is scratching their heads figuring out how they're going to deal with that. David Bowney and others in this room were very involved in the challenge of the proposed changes in rules several years ago, very successfully, I might add. There could be challenges I submit to the new proceedings under the AIA in the district courts. We'll have to see how those play. There are 146 actions from derivation proceedings to the district courts, a very complicated area. 145 actions from original prosecution to get more patentability evidence in, but it's only from original prosecution now, no longer from ex parte re-exams. That is the Hyatt case. And then, as I said earlier, I've done a whole bunch of hypotheticals to try to figure out how this world is going to look. You also need to be very concerned about how this whole world fits into the international context, particularly in the G20 countries. Now, in the book, we talk about the EPO in particular because they have an opposition process and the European market is so large. But we also talk about Japan, Canada, China, Taiwan, and South Korea. The important thing to know is each one of these countries has some type of mechanism for dealing with validity, patentability, or nullity. In some countries, they have a serial system where you go back to the patent office. In other countries, it's decided by the district court or a specialized court. In other countries, it's done in parallel. So you need to know the timelines and how this works because all those developments are going to be important in your US proceedings. 6 predictions, quickly. First, the spike. Right before September 16th, we saw a huge increase in the number of filings. In other words, more cases, more ex parte and inter party re-exams were filed in the last month than had been filed in the same prior 11 months. In other words, the Patent Office doubled their backlog of ex parte and inter party cases in the last month. How are they going to deal with that? And under the statute, they have to make their initial determination within the first 3 months. Big problem for CRU, big problem for all of us. What kind of work are we going to get? Is it going to be sloppy? Is it going to be summary? What is it going to be? The spike. I had predicted 250 cases, and I thought I was being aggressive. I know one lawyer, she told me her firm filed 43 inter-party re-exams in the last 2 days. There are some fascinating bar charts available to show the filings for the last week before the sunsetting occurred on September 15th. How do we get it all done? I talked about that earlier at the trial. How do we get it all done? How do we deal with discovery, international discovery, the timelines, no extensions of time, no oral testimony, no cross-examination, limited 30 minutes to 60 minutes interference style hearing? How do we get it all done? Who knows? But we got to, and the office does, and patent owners should be worried. Obviousness is king. This is a critical concept. As I said earlier, in the district court, you have a high burden as a challenger to find a claim obvious. It's your burden. At the patent office, the burden effectively shifts to you once the proceeding is started. The patent office is having a terrible time figuring out how to deal with evidence of non-obviousness, particularly long-felt need, failure by others, commercial success, commercial acclaim, because they don't know what the required nexus is between the evidence and the claims. They don't know how to embrace properly the evidence. So what do? They oftentimes don't let the evidence in re-exams, or they give it no real weight. That's wrong. You should be allowed, like you can in the district court, to put on all your evidence and let the deciders of the case, namely the 3 APJs, evaluate that evidence and rule on it properly. So the big difference here is you have broader claims in the patent office in terms of the broadest interpretation. You have a lower burden of proof. So patent owners should be most concerned about obviousness in these new proceedings. That is going to be the battleground. Inequitable conduct is very alive and well, as I said earlier. Be very careful in these proceedings and in your parallel district court and ITC actions that you don't create additional inequitable conduct risks as you go through this process. To stay or not to stay, that is the question. We don't know. The district courts have broad discretion, except under CBM, covered business method, to stay. So whether they will stay or not stay will need to be determined. I submit it's going to depend very much on the judge, the timing, and all the other factors. So if you're dealing with a stay fight, you better dig in deep and figure out the pros and cons for your position. And last but not least is what I call Estoppel peekaboo. These are the games that are played by defense groups and other defendants who are working together behind the curtain in a Wizard of Oz type sense, pulling the strings, working together, whether the estoppels will transfer or implicate other defendants in these cases or other third parties that are not actually named in the actual proceedings that have been brought. So Patent Office litigation is published by Thomson Reuters West on October 26th. 871 pages, 23 chapters. Here's the two-volume set. Here's the cover. You can order it now on Thomson Reuters website for a discount. And here is a table of contents for the book. Everything I covered is dealt with in the book and more. Thank you very much. I'll take questions.